Now, consideration is a key issue. This can come up on its own or mixed with something else. So you've got some right, interest, profit or benefit accruing to one party, or some forbearance, detriment, loss or responsibility given, suffered or undertaken by another. And that comes from Corey and Misa. It's unlikely you're going to remember the exact thing, but what you can think is consideration is essentially a swap. So both parties give something, both parties receive something as well. That could be service, that could be goods, it could be anything. And there's two types. We've got executed, which happens at the time of the agreement. So for example, if you buy a can of fizzy drink, then you've got the swap. You swap the money for the can and the can for the money. Or you can have executory, which is based on a future promise. So once you've outlined the type, the important thing is to know what rules you need to look at. Now, not all of these will be applicable in every problem question. What you do need to be aware of then is two things: to spot which ones are or need to be used, and then what are the exceptions to those rules. And there are always exceptions, for these rules. Now, the first one, consideration must have some value in the eyes of the law, but does need to be adequate, is illustrated in Thomas and Thomas, where £1 for the large rent of a large house was sufficient. Or Chappell and Nestle, where chocolate bar wrappers were sufficient for a record. Now, they weren't adequate, they did not represent market value, but they were sufficient and some value in the eyes of the law, and that's all they need to be. So that one is probably always going to be applicable. It's always going to be satisfied if there's some form of consideration. Really, the issues are the next three, and in fact probably 2 and 4 really that are the two that you need to analyze. So the first thing is past consideration is no consideration. So if you're relying on somebody or that's done something in the past for you, and you say, because you did that for me, I will do something for you, that's past consideration. There's no valid contract. They have given no consideration for the new agreement. This is illustrated in Rima Cardle, for example. The problem is the doctrine of implied assumpsit, and this means this payment is implied. So like in most circumstances, if you go to a hairdresser or get a taxi somewhere, you're going to pay at the end. So that if it's implied, or the relationship between the parties in the problem question indicate that they are going to be paid, then that is the exception. So even though past consideration is given, you may establish some sort of course of dealings in which they should probably have been paid. So don't forget to give both sides of the argument, and then you conclude at the end. Consideration must move from the promisee. Now, what we mean by this is the party to a contract needs to give something. That's known as privity of contract. They need to give something in order to be able to enforce obligations under the contract. So Tweddle and Atkinson was about two fathers agreeing on a sum of money to be passed down to the kids. So one father dies, they try to sue for that money, and they can't get it because they didn't give any consideration. Now that's the old rule, okay? And you've seen this in problem questions, like for example, somebody buys a washing machine for the mum in a shop. Now we know they're consumer rights issues, but it may act as like a defense privity, because you've got that idea of, well, you didn't do anything for that contract, so you should be able to enforce obligations. But what you need to do then is look at Contracts Right to Third Parties Act 1999, and that tells us specifically sort of what sort of categories of people can claim. Usually it's if they can be identified in some way. We're going to look at privity in the next slide. Now, consideration also cannot be a public duty. So or a duty generally. So if you've already agreed to do something, then you can't say, give me more money so I can complete this job. That is not good consideration. There's no fresh consideration for that. Now, this is also linked to economic duress, where people force people to pay, and they do agree, and they could possibly raise a defense of economic duress, if you like. But for this, we're just looking at this particular issue, so can it be a public duty? So what we're saying is, unless they go above and beyond, or the other party gains a new benefit, then it's not good consideration. But the flip side then, if they do, then it will be good consideration. So for example, the difference between, say, 3 people deserting a ship and the captain offering to pay them more, compared to half of the crew deserting a ship and the captain offering to pay them more to complete the journey. Well, in the second situation, they're doing considerably more, aren't they? In the first, they're just working a little bit harder, and so it would not be consideration. In the second one, it would be.